All right. Hello. Welcome to episode 7 of our immigration podcast. My name is Rob Ratliff. In the middle, Susan Hiller. And over on the other side, Ayman Soliman. I pronounced his name right for the first time in 3 years.
Even if you didn't, Rob, it would be okay.
All right. All right. So Innes was just telling us about his fancy use of President Trump's executive order against DHS. Why don't you explain that?
Sure. So the executive order executed by President Trump says that the INA, the Immigration Nationality Act, is to be enforced to the fullest extent. Now, this has a couple of ways of attacking. Everything like waivers, 237A1H, other INA entitlements. That specifically means by that order, and I cite that to OPLA, it must be enforced to the fullest extent. Another piece that's very important is that it also mentions voluntary departure, as well as withdrawal of application of admission. So if you have a client in detention and you want to get him into 240 proceedings, one argument that I've made is that President Trump's executive order specifically provides that you enforce the voluntary departure provisions to the fullest extent. Before a master calendar hearing, you have the opportunity at the first master calendar hearing to accept the voluntary departure. So one of the strategies I've been using is I say, hey, put him in 240 proceedings so we can take advantage of voluntary departure. Now, a lot of times that could be post-conclusion voluntary departure, especially for people that have been here for a long time. So what can happen is, accurately, you can take advantage of post-conclusion voluntary departure, but still put in your relief requests. And another thing that's very important is I think we have to utilize strategies.
Absolutely.
Yeah.
And are they actually then permitting someone to stay in 240 removal?
Thing that's very important.
Oh, sorry, there's a delay.
I think we have to utilize strategies. Yeah.
I'm
No,
sorry, I
definitely.
think there's a delay.
I love this. I love the way that you're using the enforcement aspect of it that that Trump and even other administrations. Oh, it's okay. Sorry. Did I cut you off?
No, not at all.
Uh-oh.
Oh, I think we lost him.
He'll be back. Connection issues.
While we're waiting for him, I love the way he's using the administration's enforcement of the INA to the fullest extent, to basically say all provisions of the INA need to be enforced to the fullest extent, and using it as a way to, garnish relief, and the applicability of relief to his or her client. Like that's excellent.
Yeah. You have to really dig through to find ways to find relief now, because there's the basics and the easy stuff are just not available.
I'm so sorry. I think that was DHS that cut me off.
Of course it was.
It's an NSA got the wiretaps on you.
So what were you saying? I mean, I'm former DHS, so maybe it was me, because I think I might have cut you off. So please proceed, counsel.
Well, we have to understand that there's specific directives that OPLA's got to follow. They have to justify it to their supervisor, especially in interesting cases and complex cases. Now, with all the detained cases and a lot of cases where there isn't available relief, I found that OPLA is now willing to work with cases where there's an easy resolution. But again, you have to justify it in the terms of the current enforcement priorities. So I've seen that when I am asking for a voluntary departure, like post-conclusion, or the ability to get to a master calendar hearing for a voluntary departure, or in cases where I want to preserve the right of someone to leave and come back without a 10-year bar, that OPLA has been open to that if I couch it in the right terms.
Well, that's great.
Are you doing that primarily?
Oh, sorry. Go ahead, Rob.
Well, are you trying that in primarily the expedited removal cases, or even people that have been here for years?
Well, people that have been here for years, but I have been trying it in expedited removal. So what I do is I write a motion to both the deportation officer as well as ERO headquarters or the regional headquarters, and I list all this law, really confuse the situation, really provide the justifications, because the problem is deportation officers are not getting back.
No.
And when you're in expedited removal, unless you meet the exceptions, you're removed. And there's no way really to get to court. But if you provide this detailed motions and so on, they think a little twice before they just execute a removal. Okay? Now, what I've seen is when I do this, my client is the only one in detention that's not transferred or immediately removed. Now, it doesn't mean you'll get a resolution right away, but at least I've seen that there's some caution. So I don't run to a habeas right away.
This is excellent news. I mean, have you gotten any of them to be placed in 240 proceedings from expedited, from these motions?
Well, the problem is the cases that I've had, what they do is they say he's expedited removed as of the day they entered. But a lot of that is inconsistent because, for instance, in one case, the client was released on his own recognizance, which there's an argument that he was paroled given the recent BIA decisions because he was subject to mandatory detention and only parole can be granted. So effectively, it's a deemed parole. And the mistake is they can't explain how somebody was expedited removed on the day they entered, but was released under order of reconnaissance and then re-detained. So you have to check the expedited removal really carefully. Because under the Biden administration, they weren't really enforcing it. They were releasing people on their own.
Going back and under the Biden administration, they weren't actually doing the expedited removal very often. And are they trying to go back and claim that 2 years ago they did an expedited removal that they didn't do, like they're backdating it?
Yes.
When they actually released them. Yeah, because they released them on their own recognizance. I mean, I actually did a detail to the border. The people who got the expedited removals were actually removed. A lot of them were under that Title 42, dealing with medical issues. And the other ones were released on their own recognizance and issued a notice to appear. So they have to be basically pretending that back then they issued an expedited removal, but they didn't, because if you're released on your own recognizance, you're paroled into the United States pending removal proceedings.
Correct.
So they're lying. And that's probably why my area in the Carolinas, the American Immigration Lawyers Association, AILA, has been saying that they're not getting FOIAs back anymore.
Yep.
They're basically being told there's nothing in the file, which is not true.
Another thing to consider.
And they're having people are filing lawsuits on the FOIAs.
Yeah. Sorry.
No, go.
I argue that they've been paroled. So that the parole has not been officially revoked. Kind of different than the CBP one where they can revoke parole. And as of such, they weren't subject to expedited removal.
So you do that in cases where they filed the NTA, or even the ones where they never filed the NTA?
The ones where they never filed the NTA. Okay? Because if we're arguing a deemed parole.
It is a parole, and I mean, it depends on the way you look at it. Sometimes they say the parole ends when the notice to appear is served on the court, but if it's not served on the court, there you go. The parole hasn't ended.
Exactly.
But it's paroled into the United States pursuant to removal proceedings, pending removal proceedings. So, I mean,
and if they never enter in the NTA, there's the issue with the 3-year bar. But if they've been paroled, they don't occur unlawful presence. Because the problem is,
when you say they don't incur unlawful presence, you mean that while they're here, because they didn't put the NTA on the court, they're not accruing any unlawful presence for even like adjustment of status purposes?
No. What I'm saying is, while I'm paroled, I don't incur unlawful presence. So if I've been deemed paroled, then during that period of time, regardless of the NTA filing, I haven't accrued unlawful presence. Why this is important is that there's cases where they will not issue the NTA until past 6 months. So if you have someone that has an eligibility for sponsorship and wants to take a voluntary departure and leave and come back and consular process, if they're not deemed paroled and the NTA is filed beyond 6 months and there's no application for relief, then they would be barred for 3 years.
Wait, so they're, by potentially them either by backlog or purposely holding on to the notice to appear. Let's go with the backlog first, and then we can say purposely later. But let's say backlog, which I witnessed, I was there when we had major backlogs with OPLA, Office of Principal Legal Advisor. And we have to review the notice to appears as ICE attorneys they're supposed to review the notice to appear before they're lodged in immigration court. So they sit in these boxes that come from the National Record Center, that come from the border, and eventually they get looked through and then filed with the immigration court. So let's say it's been over 6 months, which usually it has been. During that time, it actually is detrimental to the respondent, because if they were to leave the United States because they're accruing the unlawful presence once the notice to appear is served on the court. Is that what you're saying?
Yes. The problem is...
That makes sense.
I don't think it's OPLA's fault. I like OPLA a lot, and I think, they do the best they can. I've encountered a lot of great OPLA attorneys, so I have strong respect for them. And even ERO, when I've,
even ERO,
especially in my area, they're doing their job and they try to work with you.
they try to work with you.
Okay. Now
It's good to hear.
the problem is, I think it comes from ERO because I've seen that ERO is the one that really requests the NTA. Like I've had cases at check-ins where the DO deportation officer literally issues the NTA and gives it to me on the spot when I request it.
Yeah.
And when they want corrections or anything, they're the ones that seem like are kind of moving things along. And OPLA is really waiting for ERO. So I don't think OPLA is intentionally denying any NTAs, and I don't think ERO is intentionally delaying NTAs. It could be, but I just think that in removal practice, we're not used to a situation where an NTA is not filed past 6 months. We're usually thinking of the 1-year deadline because the law says if you occur 180 days or more, over 180 days of unlawful presence, you're barred for 3 years where removal proceedings have not been initiated. So a lot of times the 6-month date is kind of irrelevant because removal has started. Now we're seeing a situation where practitioners in removal defense have to, because of the backlogs, consider the 3-year bar issue.
Yeah.
So did back last year, Mary Chang issued the memo for the courts that NTAs that hadn't been filed in the 120 days were deemed abandoned. Did they rescind that? Did the new director? Did they rescind that?
I don't know, but I think our strategy now is we want the NTA. We want to put them in removal proceedings.
Yeah, but if they hadn't filed it within the 120 days, then you're arguing that it's a de facto parole?
No. We're arguing that the release on reconnaissance, when they're subject to mandatory detention and expedited removal.
Right. Yeah, but if they get ROR'd and issued an NTA at the border, or if they did, and then that NTA didn't get filed within the 120 days, then it's arguable that was a de facto parole.
I think the parole is the release.
Yes.
Not the NTA.
Well,
but the NTA filed with the court terminates parole.
Right.
Correct.
So if the NTA is never, even if the NTA is filed at 6 months, if that Mary Chang memo is still in effect, I don't know if it is or not, then it's arguable that it's a de facto parole. DHS doesn't file it within 4 months. They've abandoned it.
I think it has to be a parole for both. And I understand what Ennis is saying is that the fact that they're let out of custody, if they're deeming them to be a mandatory detention, then they are paroling them out of custody. But the parole that we're talking about is they're being paroled into the United States pursuant to the issuance of a notice to appear, which is in the file. They just never served it on the court. So whether or not they want to claim now that they did some type of expedite removal that they didn't execute or did not do back when they first entered, the fact that they released them on top of the fact that they initially issued a notice to appear, they were paroled into the United States pursuant to the issuance of the notice to appear. And that parole stays in effect until it's served on the court.
Right.
So it's the same argument, I do believe.
Yeah, and it doesn't matter because that memo was rescinded as part of the
Oh, it was?
total package, yeah.
Yeah.
So, no.
I don't know if Ennis is are you there, Ennis?
Yes, I am.
We can see your face, Ennis.
Yeah, looking off.
I'm
smiling.
Better and a little less delay. Well, I think that the non-filing of the NTA means that the parole that was originally granted has not been terminated.
Correct.
So it's not necessarily a second parole, but a continuation of parole. Now, they used to issue those parole authorization documents and say it's valid for 1 year. But a deemed parole, there's no real duration on there, is there? And if they issue the NTA, which they do a lot of times, before the release on reconnaissance, then isn't that a parole after the NTA, meaning parole is continued? I always, in the NTA, object to no admission, no parole, where there's an argument that the NTA was issued, and then they release them on the reconnaissance when they're subject to mandatory detention.
Good point.
So there's a lot of those cases are really, really old, though, too.
Yeah, really old.
Which would be helpful.
But for the newer cases, I think the goal is to get into 240 proceedings, because what you worry about is expedited removal. Because if it's all terminated, then they could probably reinstitute an expedited removal. I'm not sure, but I think they can. And that might be part of a strategy.
Are they still, Ennis, are they still studying master calendars, trying to get people into court before the 2 years and then arresting them?
I mean, I have seen that a lot of clients have noted that. I haven't seen that in like Buffalo or anything. But what I do is I'm kind of careful in filing or doing anything before they hit the 2 years. Like adjustment application, for instance. The asylum application, but I kind of delay a little bit on it because I'm always worried about that expedited removal. But I have heard from colleagues and so on about, the motion to dismiss to try to get the NTA out so they can put them in expedited removal. So that's one of the strategies. Right now, we want 240 proceedings. I think we took it for granted under the Biden administration that you're automatically granted 240 proceedings. Because when you're expedited removed, I mean, unless you have a claim status review, unless you're a minor, unless you're SIDGE, when you meet some of these exceptions, I mean, where do you review them? You really can't. So a lot of detention cases, we're stuck. So if you get a client that's already been expedited removed, the only thing that's going to happen is you need to kind of reopen the expedited removal, and you have to be put into 40 proceedings. So that's where I make the argument to say, okay, if their only chance is a voluntary departure, that's better than an expedited removal and you're barred for 5 years. So I make the argument that, look, President Trump's executive order on enforcing the border said enforce voluntary departure to the maximum extent. So that means reopen the expedited removal. And I've even in cases said, when there's really no relief, but I want to kind of protect their status a little bit, give them a shot in the future or something, or if they have an eligible relative or sponsorship, I'll tell them, listen, we're not going to file for asylum. We're not going to file for any relief unless something comes about that we were unaware of and unexpected. So you got to be honest with me. But put me in there so I can accept the voluntary departure. So they'll put you. So the goal is they reopen the expedited removal. They put you into 40 proceedings, and either you stipulate with OPLA for a voluntary departure, and you have to do it fast because remember when they put you into 40, unlawful presence secures,
right?
Because any parole would be terminated. Okay. So you probably want to get a quick stipulation, and you get your, what is it, 120 days max?
120 days.
And the good thing
if you take it at the master calendar, yeah.
Exactly. So if you take it at the master, But right now, masters are taking a long time. So you
Not in
want
Charlotte.
a stipulation. You want a stipulation with OPLA. It's very simple. OPLA under the regulation can stipulate, and the judge really can't, doesn't really, IJ has to follow that stipulation under the reg. Because a lot of times I've had situations where I get a case after the master calendar hearing, the judge no longer has the authority to grant a voluntary departure, and sometimes they still do, but technically on the regs, if you want to follow them, well, after the master calendar hearing, you lost your right for conclusion voluntary departure. So, but OPLA at any time can stipulate with you. So I've gotten OPLA to stipulate to VD. Also, another thing to look at is they're treating some people as arriving aliens. Right? Let's say they're an arriving alien. Okay, there is no voluntary departure for arriving alien. But what people should know is there's a reg that says if OPLA kind of consents and the judge determines in the interest of justice and the purpose of the entry or so on, they should be allowed to withdraw their application for admission. Then I've had cases where we set the final individual merits just to be a withdrawal of application for admission. And they'll allow them to withdraw the application for admission. The only problem is you have to leave immediately from the United States. So usually what I have to structure is, early hearing, in like for instance in Buffalo, they gotta get a flight to JFK and leave. So they'll have to fly to JFK and leave immediately. That's the only way it will work. So that's a little tougher, but you got to consider that for arriving aliens, especially those that have been paroled under CBP-1.
I haven't had any of those right now, but in Charlotte, they're starting to put the master calendars, move them up to within the 2 years of their entry. So what's concerning, of course, is the deportation officers are lingering there at the courtroom. And I'm even finding where usually when you've put in pleadings in Charlotte, they will reschedule it to the individual. They'll put it on for, asylum merits or, assuming you already have your application for relief, or they'll give a call update if you don't have everything in, of course. But I'm a little nervous lately because I've put in pleadings and I have not seen those cases be rescheduled to the merits hearing, the individual hearing, that they're trying to lure people in to arrest them and put them in expedited removal.
In that case, I would cite the Immigration Court Practice Manual. The Immigration Court Practice Manual specifically provides when there's an EOR 28 attorney beyond, before 5 days or 15 days, something like that, enters in appearance, enters in written pleadings, then 60 days to file application for relief, then file an individual merits. So the IJ should not, if it's following the Immigration Practice Manual, schedule a master hearing unless one of the parties makes a motion for a master calendar hearing. So I would file a motion to vacate the master calendar hearing, arguing that per the Immigration Court Practice Manual, written pleadings have been filed, that we need to follow the 60-day. We need to issue either removability finding and an order of case flow. So we got to follow
case flow. I like that.
Yeah.
Excellent.
One of the issues now, though, is you're getting the scheduling orders, especially in Cleveland. You're getting the scheduling orders. Everything's filed relief. But now things are just sitting there. No scheduled IH dates, nothing. So, there's cases that have been pending 6 months with no scheduled court date. Well, because they're trying to bump up all these new cases.
I think the problem is they're dealing with a lot of detained cases now. And detained cases are on the rocket docket, right? So the undetained cases are a little bit more difficult because, they have time. So the IJ has discretion with the non-detained where they don't with the detained cases. Even the BIA is becoming slow because they have to deal with the BIA appeal. So you want to get the BIA detained cases done and get the deportation. Okay? The removal. But
that's one of the issues, though, is there's so many people in the pipeline that are EWI, or entered without inspection, that are now subject to mandatory detention. It's the same thing. You don't want that master calendar hearing before the merits, because now these you're running the risk that DHS says, well, wait, he's subject to mandatory detention.
I think when you have a strong case, we kind of need to use the analogy of what has came down with pre-admitting applications, predetermining applications. Like, if it's not sufficient, it's not good. The BIA says that the IJ has the authority to dismiss. So in that same realm, if they have the opportunity to prejudge an application and dismiss, they would have the opportunity to do the same with approval. Now, of course, asylum might be a little bit difficult because you need credibility, you need other issues, but you got an I-45 application, everything is clear, and you really don't even need testimony necessarily. And I could see situations where OPLA would be open, but if they're not open to getting back to you or anything about it, just make the motion to pre-terminate.
Wait, would you want to pre-terminate a 485 and that you could, I guess to get it out of that, maybe that pending abyss. But other than that, I mean, the USCIS down here is especially on the older cases, it's taking them 2 years. They're actually, for example, at Charleston USCIS, I just had this conversation on the AILA email. People who are filed adjustment cases 6 months ago are getting their interviews now. People who filed them a year or 2 years ago are still waiting.
I've seen some.
So, I mean, I'm going to have to file mandamus on one of them, at least one of my cases that my client's willing to file the mandamus to have them act on his. If it's a military parole in place already been granted, the 45 is pending, all the documents are in order, they're all pending. Now, going back to the immigration court thing, if you pre-terminate it, you could end up in the USCIS abyss.
Oh, forgive me. I don't mean motion to dismiss. When I mean pre-terminate, what I'm meaning is, and I've tried this before, I use pre-terminate and I interpret it as the IJ can grant.
Oh, I get it. Yeah.
Because under the reg, they have the authority to terminate where you're prima facie eligible for relief. Again, if you're in a place where the I-45 goes smoother, then you can file under the reg, say I'm prima facie eligible, and an I-45 does not have to be filed per the reg. Or you don't even have to provide a copy technically, but you really should. The judge has the authority to terminate. So there's some strategies to consider. Like, if you have a client that doesn't have a lot of financial resources, if they're going to file an I-45, they got to pay the extra fee if they're in removal proceedings. Okay, so they might want to pre-terminate to save the money. And the problem is that waivers for non-detained cases are essentially gone by the BIA decision saying that you have private counsel and you're non-detained. The presumption is you can afford the fee. There's fee issues because now, if you see the fees are so dramatically increased that a lot of, by the time they try to pay you and they pay the fee, it's not working. And their work authorization is revoked. So you're in a situation where, unless you're doing it pro bono, you're not getting fee waivers. And the problem you also have is these motion reconsiders and they're expensive now. Everything's very, very expensive. A cancellation of removal application now from $100 some to what, $1,000? More than $1,000? So you have situations now where we also have to consider our professional ethical duties. So if somebody's eligible for cancellation of removal, adjustment of status, asylum, everything. Asylum doesn't have a necessarily high fee, but a cancellation of removal and adjustment application, you're looking at a lot of money in fees. But you want to have the backup so you don't get a Lazada if you say, I didn't give up the cancellation of removal. But they just might not be able to afford both applications.
Right.
Yeah.
So we got to take a look at that for Lazada concerns.
Yeah, and I just had to inform a whole group of people today that their first work authorization under their asylum went from $0 to $550.
Yeah.
Which is tough when you're not working.
It's tough when you're not working. And they used to be like a week. Now they take a lot longer.
Yeah.
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 All right, guys. Well, it's been about a half hour or so.
Before we go, don't you have an update?
Yes, Rob. We want to hear that great update.
Well, the DHS said in the Ayman Soliman case, said, just kidding. I know you spent 72 days in jail, but our mistake. You're out. That's
Are you
it.
going to leave us in suspense for the next podcast?
Well, no,
or
Robin's
yeah, no,
great.
yeah. Well, we don't know. We don't know. We don't know why. I mean, I have my suspicions. There were a series of mistakes in the case, I think. It started with the decisions of the asylum officer. We don't know why it was a case that was targeted for rescinding asylum. There's no indication on that. But that asylum officer's decision to terminate, all those reasoning that he had in that document was refuted by the authors. Susan and I had talked previously about the NTA with the material support allegations. It seems fairly clear now that the USCIS never had the clearance to charge those in the NTA. And that's DHS made that admission on the record in one of the proceedings. And then the last thing, the second before the last thing was the allegations regarding murder warrants in Iraq, which DHS had to file a statement that says, no, that was an inadvertent mistake. And then on the eve of briefing for our habeas case, it looked like the charging documents, the original decisions, were different. And the one that DHS had filed in the bond proceedings and filed in the immigration court had about 5 or 6 extra words, where it said not only was he had he provided material support, but that he had also been a member of a terrorist organization. And then it had the 2 different code sections for the 2 different offenses. But that was an unsigned document. It was probably, in my opinion, it was probably the draft that was circulated that went up the chain of command at DHS and didn't get approved. But that's what got filed. So why our local OPLA had a copy of that, I don't know.
That's what got filed with the judge?
That's what they filed with the court twice.
And that's not what they served on your client?
No.
Oh.
And it was so subtle. And thanks to Ennis and his AI program that he's writing, it found, I read it like twice that night. I'm like, why is this 2 different dates? And the weirdest thing of all is the letter, the one that was served on our client is dated June 3rd. The one that was the draft, it appears to be a draft, was cited May 21st. But both had that stamp, the stamp that DHS, when they stamp it before they stuff it in the envelope to mail it, they both had that same dated stamp. So at some point in time, somebody had stamped both of them on the same date.
I think also what's really important is always remember where they're admitted. There's an entitlement under the INA that DHS has to provide you all records relating to entry and so on. And I think this is a time where we're probably going to have to start using subpoenas because FOIAs take too long, especially if you're a detained case, and they might not give you a complete FOIA. It's not everything. I mean, it's very important, I think, now that if we're going to survive during this period of heightened enforcement, we really got to look at evidentiary objections, NTA objections, subpoenas, and really make these cases, because the same way we're all swamped, I mean, OPLA is very swamped too, and everyone's swamped. So, I mean, you have to defend your clients and do everything that you can. And sometimes doing that by making it, just showing that, hey, I'm really going to litigate this case. I'm not just going to concede and go to relief. I'm going to do my work. It's situations where then creative solutions like, hey, I'll concede removability, but you got to consider my application for relief in a certain way. I think that's where the creativity is going to come into play.
Yeah, and that's one of the things that we were looking at in this case, and we were getting ready to do, was file those requests for subpoenas. I wanted that asylum officer. I wanted to know why, where the decision to issue that notice of intent to terminate even came from. we've always thought all along that because he had filed a civil suit, this was a retaliation. And I think it probably might have been, but, we don't know. And unless you file those subpoenas, unless you get into discovery rather than just relying on FOIAs, you're never going to know. And it was a battle we had in this case because the asylum was so old. It was done in 2017, was originally granted. The FOIA that we did get for that original USCIS file, is full of redactions. And it's often the case, but now we're charged with redoing this asylum de novo in court with a redacted file. So that's got to be litigated. You've got to go through discovery process and don't accept, the government saying this is the document. It's an official government document. You don't need anything beyond this. You do have the rights to go through that discovery process and subpoena documents, subpoena officials. Now, whether you're going to get an immigration judge to go for it or not, that's a different situation. But when they don't, and when they say that, no, they're not going to allow you to do that, that brings you into the due process violations that you can go into federal court with.
I love this, because as a former DHS counsel, actually we used to do subpoenas. Like when I used to be in Boston, we used to do subpoenas, on the ICE side of it, the INS side. So you're just renewing the fact I actually forgot about the ability to do these subpoenas. But what's really great about them, it doesn't matter which side you're on, to be honest with this, because the judge doesn't like when he or she signs a subpoena, if it's an agency or if it's a business not complying with the subpoena and not respecting the judge's authority. Because if the judge is going to sign off on this, they're serious. And I think judges actually, I would think that most of them would be actually happy to do this because, one, it shows their authority, and when they're in a time when their independence is being attacked, or it's not as much as they used to have, let's say, with the policies.
And with these expedited calendars in the detained cases now, because they're saying that 60 days from NTA to deportation is what they want. Yeah,
and with when you have all these private counsel coming back and saying that they're saying there's nothing in the file, we all know whether you're an immigration judge or a private counsel, or you work for ICE, OPLA, that there's stuff in that file.
Yeah,
there's a file, so there's something in it. And the fact that what they're just doing is basically denying them outright, just saying there's nothing in the file. There's no time for FOIA litigation, like you said. So the subpoena would be faster, and then the judge is going to be upset if they're not the documents are not coming back. And now you're getting the judge mad at the agency, which then, again, Creative Solutions kind of helps out on your side towards due process. And look, we're just trying to get the information to have due process.
And that's something you've learned, because there's so many people that have been practicing immigration for a number of years now, but have not had to litigate those kind of issues and do the subpoenas and even get into federal court to sometimes enforce them. So it's an important skill to study up on, read, and learn.
And if I can say one thing, it's the good thing about subpoena in immigration court, or actions in immigration court, is I think there's a difference between dealing with ERO and OPLA. Again, to be honest with you, I was just say I'm a big fan of OPLA and the attorneys that I work with OPLA, because a lot of them are very great people and they're just doing a job. But they're also attorneys and they're subject to ethical rules. So when there's a subpoena that's issued, as an attorney, you understand the significance of that, and you also understand that hey, this is something that could jeopardize my license, so on. So they, with OPLA, you're dealing with them, you're dealing with attorneys, they understand the significance of it. You'll get the file. And I don't think that most OPLA attorneys, they would say there's nothing in the file. I just never see that, And I think these creative strategies, and we have to be aggressive, but we have to understand that also, administrations change every 4 years or maybe 8 years or so on. And like same way under the Biden administration, it seemed like we had the upper hand because we always had motion to dismiss. PD and OPLA really couldn't do anything except for dismiss. And now it's swung all the way the other way. But we're going to be working together for a long time, hopefully. So I think when it's good to show that, when one person has upper hand or not, always be reasonable and be creative and within the law and so on, and develop those relationships and your reputation that, hey, I'm willing to enforce everything based on the law and so on. And I'm being flat, and also working with everyone, because I think it's going to get to a point now, especially for non-detained cases, where if I'm an OPLA attorney and I have like 100 detained cases, and then I have an easy non-detained 237A1H waiver, an easy adjustment, and you've always been working with them in a good way, I can see that eventually there's going to be a little bit of flexibility for those cases, the clear relief cases, probably not asylum, but from adjustment 237-1H, Cuban adjustment, all these other cases, and those are also cases that the judge can feel comfortable in granting, because most of the time, removability is found, so DHS won their case, but application of relief was granted, so it's a win-win for everybody in a way. Whereas contested removabilities or something with no relief is kind of like one side's going to lose. But a lot of those times, like I said, if the removability can be conceded and relief is granted, everybody wins and there's no problem, no appeal. Case completion, we move on.
Yeah. You hope. All right. Thanks, guys.
You're welcome.
See you next week.
Yes.
I
can't hear you.
Muted himself.
Look at that, I'm back.
He muted himself.
I just want to say
he probably had something very astute to say.
You guys
nice
are
to
awesome.
meet you.
You guys are awesome.
Right.
And it's such an honor to be with you too.
Oh, thank you. It's a pleasure to meet you and hear your ideas are amazing.
Next one's going to be all about your AI program.
Yeah, I want him.
Hey,
God.
verify. Use it. I don't use it for motion draft or anything like that. I just use it for an extra tool. You got to make sure we're good.
Grammar.
I think we'll talk a lot about the ethics of it and so on, and making sure to prevent hallucinations. But that's a great topic.
Yeah,
I think it's well needed.
Definitely.
Yeah.
Oh, definitely. Yeah. All right, guys. We'll see you.
Thank you so
See
much.
you. Bye. Thank you.